In 1972, the Supreme Court switched the death penalty off not in one state, everywhere. Every death sentence then on the books in every state in the country became unconstitutional in a single afternoon, and hundreds of people walked off death row and into ordinary prison cells. And then, 4 years later in 1976, the same court switched it back on. Same amendment, same 14 words, the same phrase, cruel and unusual. Nothing in the Constitution's text changed between those two decisions. Not a word, not a comma. What changed was the court, and the standard it decided to measure punishment against. That is the strangest fact about the Eighth Amendment, and it is the thread we are going to pull all the way through today. How can the very same clause forbid the death penalty in one decade and permit it in the next? If the words did not move, who did the deciding? So the question for this primer is exactly that. The Eighth Amendment bars cruel and unusual punishments. Who decides what counts as cruel and unusual, and why has the single most serious punishment the state can impose been switched off, and then switched back on, under a clause that never changed a syllable? This is Do It for the Case Law. Doctrine Deep Dive Season 0, the amendments, one at a time, one sharpest gap each. Today, the eighth. Start with the text, because it is 3 prohibitions and not 1 definition. The Eighth Amendment is one of the short ones, a single sentence, 3 prohibitions, and not 1 definition anywhere inside it. No excessive bail, no excessive fines, and no cruel and unusual punishments. That is the entire amendment. 3 commands, and every one of them turns on a word the text refuses to explain. What makes bail excessive? What makes a fine excessive? A question that runs all the way into modern civil forfeiture, where the government keeps your car, or your house, or a pile of your cash, and you are left arguing that the penalty was wildly out of proportion to whatever you actually did. And, above all, what makes a punishment cruel and unusual? The framers wrote the prohibition in confident, ringing language and then left the definition completely blank. So somebody has to fill that blank case by case, and that somebody is the court. Here is the interpretive key you need before we go any further, because everything downstream depends on it. Because the words carry no fixed content, the court reads them against a moving benchmark. It looks to what it has called the evolving standards of decency that mark the progress of a maturing society. In plain English, cruel and unusual means whatever this country, at this moment in its history, has come to regard as beyond the pale. That sounds humane, and it may well be humane. A society that has abandoned branding and the pillory should not be locked forever into the punishments of 1791. But hold on to the flip side, because it is the whole ballgame. If the meaning of the guarantee can rise with decency, it can also fall, and either way, whoever is reading the standard is really the one setting it. We are going to take the sharpest gap in the amendment, those 3 words, cruel and unusual, and the punishment that has tested them harder than anything else: death. Start with the switch itself. Furman versus Georgia, decided in 1972. It is a strange, fractured decision, issued per curiam, which means there was no single majority opinion at all. The 5 justices in the majority each wrote separately for their own reasons, and no 2 of them fully agreed on the why. But the bottom line was unmistakable. Here is the holding. Verbatim, the imposition and carrying out of the death penalty in these cases constitute cruel and unusual punishment in violation of the 8th and 14th Amendments. Now notice what that does not say. It does not say the death penalty is always, everywhere, inherently cruel. The problem several of the justices identified was arbitrariness, that the penalty was being handed out so randomly, so freakishly, with so little to guide the choice, that being sentenced to death was, in one justice's image, like being struck by lightning. And on that basis, not that death is always wrong, but that this system was lawless in how it chose, every capital sentencing statute in the country fell at once. Sit with the scale of that for a moment, because it is easy to hear unconstitutional as an abstraction. It was not. Something like 600 people were under sentence of death across the country when Furman came down, and in a single stroke not one of those sentences could stand. The most final punishment the state has was, for a few years, simply unavailable. Taken off the table not by a constitutional amendment, not by an act of Congress, not by the voters in any state, but by 5 justices reading 3 words and disagreeing among themselves about why. Now the reversal, and it comes fast. Gregg versus Georgia, 1976, just 4 years later. In those 4 years, the states did their homework. They went back and rewrote their capital statutes to answer Furman guided discretion for the jury, separate trials for guilt and for punishment, explicit lists of aggravating factors that had to be found before death was even on the table. They tried to drain out the randomness, and the court looked at the very same clause and came out the other way. Here is that holding, verbatim: the punishment of death does not invariably violate the Constitution. Read those 2 holdings back to back, often 72 on and 76. Sit with that for a second, because it is doing something remarkable. The text of the 8th Amendment did not gain or lose a single letter between Furman and Gregg. No amendment was ratified. The words cruel and unusual meant in 76 exactly what they said in 72. What moved was not the Constitution but the standard the court was applying to it, plus the procedures the states had bolted on and, quietly, the people sitting on the bench. That is the moving benchmark in action, the same guarantee, opposite results 4 years apart. If a promise can be switched off and then back on that quickly without a word of the promise changing, then the real content of the promise was never in the words. It was in whoever is reading them. And the benchmark keeps moving, only this time it moves to expand the protection, not to withdraw it. Roper versus Simmons, 2005. The question was whether a state may execute a person for a crime committed while they were still a minor. The court said no, holding verbatim the 8th and 14th Amendments forbid imposition of the death penalty on offenders who were under the age of 18 when their crimes were committed. Here is the tell that makes Roper perfect for this episode. The court had squarely held the opposite just 16 years earlier. Same clause, same country, and in 1989 the answer was yes, you may. By 2005 the answer was no, you may not. What changed? The court counted up the state legislatures, saw that more and more had abandoned the juvenile death penalty, called that a national consensus, and declared that the standard of decency had evolved. A few years later it did the same for people with intellectual disability. This is the amendment at its most alive and most muscular, drawing bright, categorical lines about who may be executed at all. And that word consensus is where the real deciding happens, so it is worth being honest about it. When the court says the standard of decency has evolved, it claims to be measuring the country to count statutes, tallies which way the states are trending, sometimes glances at how the rest of the world punishes. But the choice of what to count, and of when a trend has hardened into a consensus, and of how much weight to give the direction of change rather than the raw head count, those are judgments, not measurements. And dissenting justices in these very cases said exactly that, accusing the majority of dressing up its own moral preferences as an objective reading of the nation's. Whichever side you find more persuasive, notice the structure. The meaning of a constitutional guarantee is being set by a contested count, run by the same 9 people whose values the guarantee is supposed to be checking. And Roper was not alone. 3 years before it, the court had already drawn the same kind of categorical line around a different group, and that case shows you the machinery working at full strength. Atkins versus Virginia, decided in 2002. The question was whether a state may execute a person with intellectual disability. 13 years earlier the court had said yes. In Atkins it reversed itself. Here is the holding, verbatim, and I am going to read it in the court's own words of the time. Construing and applying the 8th Amendment in the light of our evolving standards of decency, we therefore conclude that such punishment is excessive, and that the Constitution places a substantive restriction on the state's power to take the life of a mentally retarded offender. That phrase, mentally retarded, is the language the court used in 2002. Its own terminology has since moved to intellectual disability, which is itself a small illustration of standards evolving underneath fixed words. Watch the reasoning, because it is the same engine as Roper. The court counted state legislatures and found that a growing number had abandoned the practice. It called that a national consensus. It added its own judgment that executing people with intellectual disability would not measurably serve deterrence or retribution, the two purposes the death penalty is supposed to serve. And on that combination, it took an entire category of human being permanently off the table. No amendment, no act of Congress, a count, a judgment about purposes, and a categorical bar. Then the court did something more interesting. It took the reasoning off the death penalty entirely. In 2012, in Miller versus Alabama, the question was not execution but imprisonment specifically. Whether a state could impose a mandatory sentence of life without any possibility of parole on someone who was a child when he committed his crime. One of the defendants was 14 years old. Mandatory means the sentencing judge had no discretion on conviction. That sentence followed automatically, with no opportunity to weigh the defendant's age, his home life, or his capacity to change. Here is the holding, verbatim. We therefore hold that mandatory life without parole for those under the age of 18 at the time of their crimes violates the 8th Amendment's prohibition on cruel and unusual punishments. Notice how far that travels from where we started. Furman and Gregg were about the machinery of death. Roper and Atkins were still about who may be executed. Miller is about a prison sentence. And it says the 8th Amendment has something to say not just about whether the state may kill you, but about whether it may lock you away forever without ever looking at who you actually were when you did it. Read carefully though, and notice the word doing the work, mandatory. The court did not say a juvenile can never receive life without parole. It said the sentence cannot be automatic, that someone has to consider the individual child before imposing it. That is a real constraint. And it is also a narrower one than it first sounds. The amendment is at its strongest here, and even at its strongest it is regulating how the decision gets made rather than forbidding the outcome. Now I owe you a correction, and it is the good kind, the kind where the doctrine turns out to be older and stranger than the tidy version. Miller was not the first time the court took this reasoning off the death penalty. It was the second. 2 years earlier it had already done it, and in some ways gone further. Graham versus Florida, decided in 2010. The question was whether a state may sentence a person to life in prison with no possibility of parole for a crime committed while he was a juvenile, where the crime was not a homicide, nobody had been killed. The sentence was still permanent. the rest of his life, with no door at the end of it, and the court held the Constitution forbids it. Here is the holding, verbatim. The Constitution prohibits the imposition of a life without parole sentence on a juvenile offender who did not commit homicide. Now listen to the second half of that holding because it is the half people drop and it tells you exactly how far this amendment is willing to go even at full strength. Verbatim again. A state need not guarantee the offender eventual release, but if it imposes a sentence of life it must provide him or her with some realistic opportunity to obtain release before the end of that term. Rather slowly. The court did not order anyone released. It did not shorten a single sentence. It said the state has to leave a door, some realistic chance at some point, for the person to come back and show he is not who he was at 17. That is the whole remedy, not freedom, the possibility of asking for it. So even here, in the amendment's most muscular mode, drawing a categorical line around a whole class of human being, what the court actually hands the prisoner is a procedure. So on that side of the ledger, the whether, the who, the Eighth Amendment is wide awake and moving. But there is a second half to the amendment's job, and it is where the energy drains out. It is one thing to ask whether the state may impose a punishment on a whole category of people. It is another thing entirely to ask how the state may treat the people it is lawfully punishing, the conditions inside the prison, the mechanics of the execution itself. On that second question, the same amendment turns out to be a great deal weaker. Estelle versus Gamble, also 1976, this one about medical care behind bars. The good news for anyone who cares about how prisoners are treated is that the court held the Eighth Amendment does reach the conditions of confinement. A prison is not a constitutional free-fire zone. But then look hard at the standard the court actually set. Verbatim, deliberate indifference to serious medical needs of prisoners constitutes the unnecessary and wanton infliction of pain prescribed by the Eighth Amendment. Deliberate indifference. Underline both words. Not negligence, not malpractice, not a merely terrible outcome. To win, a prisoner has to prove that an official actually knew of a serious risk to their health and consciously turned away from it. A doctor who is sloppy, a guard who is careless, a system that is simply overwhelmed and understaffed, that is not enough, no matter how much a human being suffers as a result. The protection is real, but the bar to clear it is set very high. And the how question gets harder still when the punishment is death and the fight is over. The method. Bucklew versus Forsyth, 2019. This was not a challenge to the death penalty in the abstract. It was a challenge to a particular execution brought by a man with a rare medical condition who argued that the state's lethal injection would likely cause him to choke on his own blood as he died. The court rejected the claim, and along the way it stated the governing principle in a single blunt sentence. Verbatim, the Eighth Amendment does not guarantee a prisoner a painless death. And then it spelled out exactly what a prisoner must prove to win a method of execution challenge, and this is the part to really sit with. The prisoner must show a feasible and readily implemented alternative method that would significantly reduce a substantial risk of severe pain and that the state has refused to adopt without a legitimate penological reason. Read that slowly. To prove that the way the state plans to kill you is unconstitutionally cruel, you have to come into court and hand the state a better, workable, ready-to-go way to kill you instead, and then prove it refused to use it for no good reason. The condemned is made to design his own execution. That is how demanding the how side of this amendment has become. Put Estelle and Bucklew next to each other and the pattern in the how cases jumps out. In both, the court concedes that the amendment applies, conditions of confinement count, the method of execution counts, and then it sets a test so demanding that the concession costs the state almost nothing. Deliberate indifference, not mere carelessness. A feasible alternative the prisoner has to supply, not a burden the state has to carry. The door is technically open, it is just built to be nearly impossible to walk through. That is a very different posture from Furman and Roper, where the court was willing to shut whole doors on the state entirely. Which brings us to the gap, and it comes in two parts. First, hold the two halves of the amendment side by side. On the whether and who question, may the state execute this whole category of person at all, the Eighth Amendment is alive and moving. Furman switches it off, Gregg switches it back on, Roper carves out juveniles, later cases carve out people with intellectual disability, and the court keeps redrawing categorical lines as the standard evolves. But on the how question, the conditions you are held in, the specific way a lawful sentence is carried out, the amendment goes quiet, fenced off behind deliberate indifference and feasible alternative tests that almost never come out for the prisoner. So the guarantee polices whether the state may punish far more energetically than it polices how the state punishes. The uneven application in this episode's title is not an accident, it is the shape of the doctrine. And second, the deeper problem sitting underneath all of it, the content of cruel and unusual is, in the end, whatever a current majority of the court finds decent. That is what evolving standards really means. The protection has no fixed floor. It rises and falls with the makeup of the bench, not with the words on the page. The same 14 words forbade the death penalty in 72 and permitted it in 76, not because the country amended anything, but because the court's read on the country's conscience, and the court's own composition, had shifted. Every other clause in the Bill of Rights at least pretends to a fixed meaning it is merely recovering. The Eighth Amendment is the most openly value-laden guarantee of them all. It tells you honestly and to your face that its meaning is a reading of the national mood, a reading taken by 9 particular people, at one particular moment, and revisable by the next 9. So far, every case in this episode has been about the third prohibition, cruel and unusual punishments. But remember, there were 3, and one of the others spent almost the whole of American history asleep. It woke up in 2019, and the case is worth your time because it is where this amendment touches ordinary people who were never anywhere near a death chamber. Tyson Tim sold a small amount of heroin to undercover officers in Indiana. He pleaded guilty. The maximum fine the state could impose for his offense was $10,000. The state also seized his Land Rover, which he had bought for around $42,000 with money from his father's life insurance policy, more than 4 times the maximum fine, taken through civil forfeiture. A proceeding formally filed against the vehicle rather than against him. Timms argued the forfeiture was an excessive fine. Indiana's answer was not that the amount was reasonable. Indiana's answer was that the excessive fines clause did not apply to the states at all, and that argument was not frivolous, because the Supreme Court had never squarely held that it did. A clause of the Bill of Rights, ratified in 1791, and in 2019 it was still an open question whether it bound a state government. The court closed it. Here is the holding. Verbatim, the excessive fines clause is therefore incorporated by the Due Process Clause of the 14th Amendment, unanimously and with a reason that matters. The court described protection against excessive economic sanctions as both fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition, the test for whether a right binds the states. And in explaining why it still matters now, the opinion took note of an argument pressed by outside parties in the case, that because fines and fees are politically easier to impose than general taxes, state and local governments have come to lean on them heavily as a source of revenue.
That is the modern stake.
Not a rare atrocity, a routine revenue stream, running through traffic courts and forfeiture dockets, in which the government has a direct financial interest in the size of the penalty it imposes on you.
And now put Timms next to everything else in this episode, because it sharpens the whole picture.
The death penalty cases show an amendment that is intensely alive on the question of whether the state may impose its most extreme punishments, and that got there by reading a moving standard of decency. The conditions and method cases show that same amendment going quiet on how punishment is actually carried out. And the excessive fines cases show a third pattern again, a prohibition that was simply dormant, doing nothing for more than 2 centuries, not because anyone decided it was unimportant, but because nobody had made the court answer the question. Same 14 words, 3 completely different tempos. And the forfeiture story does not stop in 2019. It has a sequel, and the sequel went the other way. Cully versus Marshall decided in 2024. Halima Cully loaned her car to her college-age son. Officers in Satsuma, Alabama stopped the car while he was driving, found marijuana and a loaded handgun, arrested him, charged him with possessing marijuana, and seized the car. A second woman in the consolidated case, named Sutton, had lent her car out too. Neither woman was the person accused of anything. Both lost their cars into the forfeiture machinery, and both sued under the federal civil rights statute, arguing that due process required something Alabama had not given them. A quick preliminary hearing, up front, just to decide whether the police could keep holding the car while the real forfeiture case ground forward. The Supreme Court said no. Here is the holding, verbatim, and listen to the first 6 words because they are doing real work. In civil forfeiture cases involving personal property, the Due Process Clause requires a timely forfeiture hearing but does not require a separate preliminary hearing. Personal property, a car, cash, a phone, something that can be driven off, spent, or hidden before a hearing. The court was careful to say the rule is different for land. Due process ordinarily does require notice and a hearing before the government seizes real property, precisely because a house cannot be moved in the night. So the decision is narrower than the headline, but narrower in a way that lands hardest on people whose most valuable possession is a vehicle. Sit with what that means for a person who needs their car to get to work. You are entitled to a hearing. You are not entitled to a fast one at the front end. And in the gap between the day the car is taken and the day your case is finally heard, the car is simply gone. And you are absorbing that loss whether or not you are ever charged with anything, because the case is formally against the car. Which is exactly why the 2019 decision was never the finish line. And Timms is a beginning, not an ending. It settled that the excessive fines clause binds the states at all. It did not settle how much is too much, which is the very same open question that Cruel and Unusual has carried from the start. That is a full season story of its own, and it makes the point this whole episode has been circling every one of these 3 prohibitions as a firm-sounding command wrapped around a word the court has to fill in, over and over, as the standards move underneath it. That is the sample. A full Amendment 8 season on this show would take each of the 3 prohibitions in turn, excessive bail and what excessive even means before trial, excessive fines, and the whole civil forfeiture story of the government keeping what it sees as the death penalty in its full arc, from Furman and Gregg through the categorical carve-outs for juveniles and for people with intellectual disability, and on the other side of the line, prison conditions and the method of execution, 1 doctrinal question per episode, each one anchored in cases we verify, not cases we merely remember. A quick word on how this show works. Everything you just heard is legal education, not legal advice. We are are teaching how the doctrine moves, not telling you what to do if you are ever the person standing in front of that sentence. And all of it is built on real, named, verified cases. Furman, Gregg, Roper, Estelle, and Buckaloo were every one of them pulled from the court's own opinions before I wrote a single word, and every citation is sitting in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.